law attorney of the group. Today I'm going to discuss prenuptial agreements, which I think is an interesting and relevant topic to all of us. Some of you may not know that Florida is one of only 7 states where you can actually do a postnuptial agreement. And that means after you're married, if you want to sit down with your spouse and discuss a division of property or an alimony agreement post-marriage, then you can do so, and it will be valid, and you can modify it as many times as you want. I will tell you, in my practice, I've been hired many times to do postnuptial agreements, and they are never signed. I think that once people are married and they're in a romantic relationship, it's a very, very difficult topic to discuss at that point in time. Prenuptial agreements are hard enough for anyone who's ever discussed one, they know. And postnuptial agreements, although they're legal, they're enforceable in Florida, they're just, they're rarely signed. So prenuptial agreements are a tough sell for clients for many reasons. Number one, they're an agreement and a contract that people don't really want to discuss for the obvious reasons. Nobody wants to think that they're going to marry someone and one day they're going to get a divorce. And I always try to tell my clients, I hope this is the most unimportant document you ever sign, okay? That's literally one of the things I tell them. Also, for me, as a litigator, I'm in court a lot. Everyone in the room knows family law disputes are really difficult. They're really emotional. So a prenup or a postnup, it's kind of one of the only nice things that I do. Because it's kind of like a happy thing once it's signed, the people, they actually get married, and generally we hope that they're happy in the future. Some of the things that you can do in a prenuptial agreement that people don't realize they can actually contract away. First of all, one of the important reasons to do a prenup is to address the issue of attorney's fees. So one thing that people don't realize in Florida is that if you're in a family law dispute, you can get the other side to pay your attorney's fees and costs if you make significantly less money. So the superior earning party, whether it's a paternity case where the people have never even been married, or whether it's a divorce, the superior earning party can be responsible for not only his or her fees, but the other party's fees. This is important because when somebody's not paying for his or her attorney's fees and costs, they don't really have an incentive to settle. They don't really have an incentive to end the litigation. So one good reason to do a prenuptial agreement is to address attorney's fees and costs. Now, there are certain attorney's fees and costs that you cannot waive in a prenuptial agreement. Those are your temporary. Those are what's referred to as temporary attorney fees and costs. And those are the ones that take place while the case is actually pending. However, if you do a prenuptial agreement, you can put a cap potentially on them, and you can also, not in full, not the entire temporary attorney's fees and costs, but you can address in the agreement that should the other party move to set aside the prenuptial agreement and they lose, then they are responsible for both sides' attorney's fees and costs. Attorney's fees and costs in litigation, all the attorneys in the room know it is a really big issue. So the fact that you can put in this prenuptial agreement that there's a limitation on fees is a real advantage. Another matter that you can address in a prenuptial agreement, which is really important, would be how your property is disposed of upon your death. So, for example, you can waive what is known in Florida as the elective share. The elective share is what a spouse is entitled to when another spouse dies pursuant to Florida statute, even if there's no will. You can also include in the agreement that the other person not be able to inherit any of your property at all. You can basically disinherit your spouse if you want in a prenuptial agreement or a postnuptial agreement. The only thing you want to be certain of, and this is really important, is that those documents are consistent with any will and trust that you also sign, because you don't want upon your death to have these types of contracts not be consistent with one another. Okay, so another big area that can be addressed in prenuptial agreements is equitable distribution. So what does equitable distribution mean? That means the division of your property, your assets, and your debt. So a lot of people don't realize that when they get divorced in Florida, if they don't have a prenup, their retirement account is marital. So any money that you have saved in your retirement plan, whether it's an IRA, whether it's a 401k, whether it's a pension, it's all marital. The only way it's not is if you do a prenuptial agreement. It also doesn't matter if you started your job before the marriage. So let's say you have a husband who's been working at Miami-Dade County for 20 years when he gets married. The marital portion, meaning the time that he has been married and has invested money in his retirement plan, or that his employer has invested on his behalf, all of those funds are actually marital. Okay, so the increase in value during the length of the marriage is a marital asset. It also doesn't matter if you have two parties in a marriage, and I've seen this many times where one party is a spender and one party is a saver. It's very common you see that one person is making hundreds of thousands of dollars a year, another person's making $50,000 a year, the superior earning spouse spends, doesn't save anything at all, then you come to get a divorce, you're dividing the person who saved a lot's savings, retirement, everything. It's marital.